Welcome to Atlanta Estate Planning with Terry McGinn.
Welcome to Atlanta Estate Planning with Terry McGinn. Terry is an estate planning and probate attorney based in Marietta, Georgia, helping individuals and families put clear, practical plans in place to protect what matters most. I'm Shameika Rhymes, and today we're talking about what actually happens in an estate planning consultation in Georgia and the key questions that Terry walks through with every client. Welcome, Terry.
Hi, nice to meet you, Shameika. I'm excited about being here.
Nice to meet you. Well, let's talk about what happens in an estate planning consultation. So, Terry, to start, can you explain what that first estate planning consultation with you actually looks like?
Yeah, Shameika. So what basically happens is I go through basically the dynamics of me constructing a will for my clients. And that's a process where I go through and explain executors, beneficiaries, who gets the assets, the actual mechanics of how Georgia probate law will give or devise their assets to their loved ones, whoever's listed on the will, in their wishes. I make the distinction often between a will in which somebody passes away and it's a probate case, meaning a will that's backed up, a probate case where a will is the underpinning, and where there is no will. I get a lot of people who don't have a will and they say, what do I do? That's called an intestate petition. And it's basically the same foundation, except that in the beginning, I get the chance to explain to people what the mechanics are and how their wishes actually could be able to be transferred to the people who you want them to go to versus a court to decide that. So I go through the will first. I follow up with going over another document I normally supply, which is called an advance directive for healthcare. We used to call that in Georgia living will. It has to do with healthcare issues and who you want to appoint as a healthcare agent to help you through at the end of your life and how your remains are going to be treated like that. That's a fun conversation. And the third thing I do is basically talk about a durable power of an attorney for financial matters. If my clients are incapacitated, who do they want to be able to pick up the ball on that and help them until either they pass away or they're able to conduct business again. So that's the basics of what I go through in the beginning.
Okay, so you begin by gathering basic information like legal names, dates of birth, and address, but what problems can come up later if those details aren't clear from the start?
Big problems. Because if typically what I see in my practice is from a will that either I made where my client forgot to or purposely forgot to let out or not include who a beneficiary is or who's to receive in the will. And that's a problem because if it's an inadvertent mistake, what will happen is the person who's left out is typically an heir, and we'll go into what that definition means, but they will also have they'll have the obligation to refile the petition. Petitions in Georgia normally, or administration of estates in Georgia normally take anywhere from 90 days to 4 months. This could double or triple that time because what happens is if somebody's left out who has a say in the estate, they have a right to file an objection and to stop the process and have it start all over again. That's the biggest problem I see in that. If it's done purposefully, if they've intentionally left them out, then that's a bigger problem because then the person that's been intentionally left out of the will under Georgia law has the ability to stop everything, file a lawsuit, ask for the court to insist that the executor or the administrator file what's called an accounting of all the assets and money that's paid into or from the estate. That is a problem because if there's irregularities, the court might decide in its judgment in a litigation trial, typically, that the executor or administrator needs to be dismissed. That throws everything out in the open. And then I've been involved in having county administrators take their place to get to start all over. So that's a real problem. So that's why it's a good question. at the beginning of the process, information needs to be disclosed and all the hard facts brought out as to who are your relatives, et cetera, and why they need to be included.
I think, you mentioned what is an heir. Can you tell us what is an heir?
Sure, an heir is a blood relative of the deceased. So, a son of a beneficiary a testator is an heir. A wife is an heir under Georgia statutes. Maybe we can get into that in a minute. Anybody who's a blood relative, a direct blood relative, meaning children, grandchildren, etc., of the deceased is an heir. The heir might not and likely is not listed in the will as a beneficiary. Beneficiaries, on the other hand, heirs can be beneficiaries because they're a direct relative of the deceased, but they also can be listed as somebody who's going to get a benefit, meaning a beneficiary. So oftentimes beneficiaries might not be an heir, might not be any relation at all. Maybe it's a cousin that I like, or maybe it's somebody I went to high school with years ago. I want to give them something. They're a beneficiary, but they might not be an heir. So that's the distinction. And an heir has the ability, as I say, to legally step in and file what's called a caveat to the estate or an objection to the estate, throws everything into a tumble.
Ah, okay. So obviously a big part of your initial consultation is meeting and understanding someone's family. So what are you
Right.
trying to map out when you're asking about children, blended families, or prior relationships?
Great question. So the issue really boils down to a couple of things. Who are considered children or heirs of a beneficiary, of a testator? I keep mixing that up. Of a testator, or the testator is the person that wrote the will. That's the person giving the gifts. So, who are the children legally that can be considered as heirs? Well, obviously, blood children, children born from the birth of the person who's deceased, is a blood heir. There's some couple of peculiarities in the law in Georgia that say adopted children can be considered a blood heir. Now, an adopted child, by definition, is somebody that wasn't born into the family, but the person who adopted them said, "You are a member of my family." Legally in Georgia and other states is, I'm going to treat you legally and is recognized by a court order that you're my son or my daughter. Okay? And so that person, though not a blood relative, is now considered a legal heir under a Georgia court order that you're adopted. You're on the same level. I've adopted you as my son. You're on the same level as my other children legally as far as their ability to receive benefits. So adoptions nullify any outsider standing for a child adopted into the family. What about stepchildren? So stepchildren in Georgia are half brothers and sisters, typically are defined as the stepchild is a person who maybe is descended from a parent who is not the deceased from a different marriage, and they are a relative of the deceased. So a stepchild or stepbrother and sister is a person who is not related to both of the parents in the family. From a previous marriage, etc., that person brought a child from the previous marriage into their current marriage and had other children. That's a half brother and sister or a step brother and sister to the other children. Under Georgia law, they're treated just like as if they were a full-blooded person born of the marriage, and there's no distinction between stepchildren or stepbrothers and sisters and full-blooded brothers and sisters. They're also 100% included in the statutory constraints in Georgia. Who's not included? In-laws are not included, okay? So I happen to have a dear mother-in-law. She loves me, and why not? She loves me, but what she has done in the past is she included me being married to her daughter as a beneficiary in her will. I'm explicitly included in the will. That's an unusual situation. So I'm a beneficiary, okay? But in the event, God forbid, my wife and I split up and she passes away before she's become deceased, she doesn't have to write me out of the will because I'm an in-law and I'm no longer legally married to my wife. So even though I'm a beneficiary in the will, I'm excluded under Georgia law because there's no now legal relationship between me being her legal son-in-law. Now that a divorce court has said we're separated, I'm no longer included or can qualify under the benefits in Georgia. So in-laws typically, typically they're not listed in the will, but even if they are listed in the will, if there is a divorce that was culminated before the deceased and the deceased didn't have a chance, obviously, to change the will to cut them out, there's no need to do that. In-laws, whether they're mentioned or not in the will, do not qualify for any benefits under the will unless they're specifically noted as a beneficiary. So in-laws are out. And I mentioned divorce parties, they're out as well. So those are the kind of the peculiarities in most states where who's able to be a member of the family legally under probate law and who's not.
Well, if someone has younger children, what decisions do they need to make right away about guardians and how those kids will be provided for?
I normally always include in my wills what's called a testamentary irrevocable trust. Mouthful of words. What does that mean? That means that in the event both of the parents, and this is exceedingly small chance of happening percentage-wise, but it has happened. I've done one case where I've seen this. But both the parents become deceased when there's minor children below the age of 18 in Georgia. A trust is created for that child or children from the assets that are part of the estate now paid from the benefits of the last deceased parent to care for the care and well-being of the minor child. When that child, and so what's required here is that in my wills, I request a couple of things. Who do you want to be the guardian of the child? Because you're both gone. The guardian's job is to have the legal responsibility to raise the children and care for them until they reach the age of 18. Most of the time, guardianship dissolves at age 18. There are a couple of circumstances where there might be a circumstance where the guardians want to extend that a little bit, but that's normally not the case. 18 is the age of majority in most states. The other aspect is they need to appoint a trustee. A trustee is the person who's got counter responsibilities from the guardian, in that the trustee is responsible to administer the funds for the care and the maintenance of the children that are being raised by the guardian. And so there is a tension that's applied legally in most cases. The person that's raising the minor children is the one that's got all the legal and ethical responsibilities to take care of them competently. The trustee has a separate responsibility to make sure the assets of the estate are preserved and any funds requested by the guardian are paid for a valid reason. That creates, in my estimation, a legal tension. I need the money to raise the children. I've got the legal responsibility to make sure the money that's paid to you goes for the correct cause, and I'm also preserving the assets of the estate. It's for that reason, so they butt heads. It's for that reason why I normally recommend, it's not an ethical constraint or otherwise or legally, that whoever's going to be the guardian is also the trustee, so that relieves that tension. Now, the question might be, yeah, but what about if the trustee and the guardian have misused the money? Yeah, that's possible. The guardian and the trustee are both voluntary offices, and anybody can bring a claim against them for any personal injuries or any loss of money, I should say, that's squandered by either the trustee and or the guardian, and they can be held personally and financially responsible if a court finds that they've not discharged their duties. So that's one of the reasons why both an executor who's in charge of administering the will when it is first probated, along with the guardian and or a trustee, if that is involved, has a legal obligation that they can be personally responsible for in a court if they're sued. That's got to be paid out of their own pocket, whatever the damages are. And these offices are voluntary. So that's another issue that I try to stress to my clients, that you can name whoever you want, but I strongly recommend you make sure they understand what their legal liabilities are going to be so they're informed, so they don't have a problem so that somebody goes, I never knew about it, I don't want to do it. So that's part of what the issues are.
Okay. Well, as we wrap up, I just wanted to make sure we get this question really quick. But when it comes to choosing an executor and you're settling things like we were just talking about, like when a trust would pay out, what decisions tend to require the most thought from clients?
So yeah, that's a great question, Shameika. So the biggest thing is, when is the beneficiary or the person that's going to get the money get the money? That's at the discretion of the person creating the will, essentially in the beginning. So if it's a minor child, that's the beneficiary, either directly or indirectly, as we spoke about. There's a number of facilities. There's a pour-over will that we talked about. The pour-over will, or whether there is a trust created or not, the will can designate that I don't want any of the beneficiaries to receive any funds in this account until they reach the age of X. For example, if it's a minor child, it's going to go into the trust until they reach the age of 18. However, in the trust documents that I prepared, the irrevocable testamentary trust that we talked about a minute ago, I always say, let's make the age that the children get the money is different from 18. When I was 18, I couldn't have had money, any real money. Okay, good. I'm glad you're right.
Yeah, so, not even at 21.
Yeah, exactly. Well, me too. Of course. So, but the issue is, so we can do a step in there. We can say the trust for that particular child is not going to receive any funds directly until they reach the age of 20, 21, 25. Typically 25 is when most people are done with their secondary education. 25 is when they're out in the world, and that's when a lot of people say, yeah, the guardianship will dissolve when it's 18, but when they turn 25, yeah, let them have their money. And if it's two children in the trust, two minor children, when the first one reaches the target age of dissolution, they'll get their portion of the trust in a check and they're good. When the second child reaches the target age of dissolution, that's when the trust dissolves and they're good.
Okay. This has been such an informative conversation, Terry. Thank you for this.
Good. Nice to do it. Glad to do it. I look forward to speaking with you again.
Absolutely. Well, that's it for today's episode of Atlanta Estate Planning with Terry McGinn. In our next episode, we'll continue this conversation and walk through the key documents that complete an estate plan in Georgia and the real decisions clients make around healthcare and financial authority. If you'd like to learn more or schedule a consultation with Terry, visit lawga.com. Thanks for listening, and don't forget to subscribe, share, and leave a review so more Georgia families can get the guidance they need.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.